your skies.
All right. Hello, everyone. My name is Shakayla Alvarenga. I'm the Director of Public Programs here at the Mob Museum. Thank you for being here tonight. This will also be live streamed, so thank you to those joining us online as well for tonight's discussion. So I'd like to introduce our panelists for this evening. To our right, Jed Rakoff has been an adjunct professor at Columbia Law School since 1988 and has served since 1996 as a federal district judge for the Southern District of New York. Rakoff served as a federal prosecutor in the U.S. Attorney's Office for the U.S. District Court for the Southern District of New York, where he was chief of business and securities fraud prosecutions and a white-collar criminal defense lawyer at two large New York firms. Rakoff is a commissioner on the National Commission on Forensic Science. He also served as co-chair of the National Academy of Sciences Committee on Eyewitness Identification. He also serves on the executive committee of the New York City Bar Association. He has co-authored 5 books, written more than 140 published articles, and delivered over 600 speeches. He is the author of Why the Innocent Plead Guilty and the Guilty Go Free and Other Paradoxes of Our Broken Legal System. To my left right here, Tierra D. Jones is currently a district court judge in Department 10 of the 8th Judicial Court, District Court, I should say. On April 27, 2017, Governor Sandoval appointed Tierra to the district court bench. Tierra became the first African-American woman to serve on the district court in the state of Nevada. Her case assignments consist of both criminal and civil cases. She attended the William S. Boyd School of Law and obtained her doctorate in 2006. After passing the state bar, she worked for the Office of the Clark County Public Defender. She then began her prosecuting career at the Nye County District Attorney's Office and later moved on to the Clark County District Attorney's Office. During her time as defense attorney and a prosecutor, Judge Jones appeared in court almost every day. She completed more than 35 jury trials, including several high-profile cases. She also argued before the Nevada Supreme Court. Please give both of our panelists a round of applause. So there are quite a few topics that we'll cover in the next 45 minutes or so, including plea deals, sentencing guidelines, and the perils of eyewitness testimony in forensic science. If you have any questions throughout tonight's discussion, we will use the last 10 minutes or so to get to that audience Q&A. So let's get started, a lot to get to. So before we get into specific questions, I'd like for you both to just talk generally about why you chose this field as a career and how you got to where you are today. And anyone can begin.
Well, I decided I wanted to be a lawyer when I was an undergrad. I thought that would be the best opportunity I would have to be able to help people and to be able to assist the community where I was. So when I moved to Las Vegas in 2003 to go to law school, I wanted to be a part of this community, and that's how I felt like I wanted to make a difference. And I always knew I wanted to be a judge because I felt like the judges had the ultimate amount of power to make that difference. And I wanted to be well-rounded by the time I took the bench, so I wanted to be a prosecutor and be a defense attorney so that in the criminal field, I would have seen both sides of the criminal arena. So I did get an opportunity to do both before I was appointed to the bench in 2017. And after I had done both for approximately 10 years, I decided it was time to make the change to being a judge. So I took the bench in 2017, and it's been a great ride. I mean, it's been amazing. I have had a very interesting career. I've gotten to preside over some great cases. I've gotten to see a lot of my cases where I made decisions that really matter to people and change people's lives. So it's been really, really rewarding, and I look forward to a long tenure on the bench. This is only year 4, so I have a lot more time to go.
So I'm Jewish, so I was supposed to be a doctor, but I couldn't stand the sight of blood, so I decided to become a lawyer instead. was always attracted to trial work. I still think there's nothing quite as exciting as a trial. So first I went as a federal prosecutor in New York, and I was mentioning to the nice family right here, that I was particularly glad to be here at the Mob Museum because one of my prosecutions was a guy named Carmine Tremonti, who was the head of the Lucchese crime family, and I'm looking forward to meeting his ghost later in the program. Then I became a criminal defense lawyer, and I very much agree with Judge Jones. I think I've become a better judge by seeing both sides of the coin, so to speak. And finally, I decided it was really hard to be a trial lawyer. It requires a lot of stamina. I need a soft, cushy job, so I applied to be a federal judge, and I've been one for the last 25 years.
Thank you. So, as I mentioned, Judge Rakoff is the author of the book, Why the Innocent Plead Guilty and the Guilty Go Free and Other Paradoxes of Our Broken Legal System, which came out in February, correct?
Yes.
And so if you haven't read it yet, it is really a fantastic book that details the complexities of the criminal justice system. One of the statistics in the book, at least 500,000 of the 2.2 million people now incarcerated have not been convicted of any crime, but are simply in jail because having been arrested could not make bail. So let's just talk a little bit about the original purpose of bail versus the current money bail system. And Judge Rakoff, we can begin with you.
So this is, of course, just one part of what I consider the biggest problem in our criminal justice system, which is mass incarceration. We'll talk more about that later. But we lead the world in the number of people we lock up. And for every year since about the year 2000, it's been about 2 million. And of those, typically about a quarter are people who have not been convicted of any crime, but simply cannot make bail. Now, the Eighth Amendment of the Constitution says that there should not be excessive bail. And that actually dates all the way back to Magna Carta. But it's something of a myth. The judges, both state and federal, set bails that they know cannot possibly be met. And why do they do that? It's because they are already convinced, even though there's been no trial, that this person who technically is presumed innocent must be guilty and would be a danger to the community if he was left out there on the streets. This is not based on any science. It's not based on any good studies. And yet it comes natural to too many judges. And so if they're at a bail hearing and they hear, oh, this is a bad guy, Judge, we think we have him cold, they're going to lock that guy up. And the device they use is by setting a bail that is so high that they know that this particular person will never be able to make it.
And I mean, following up a little bit on that, Nevada, in the state of Nevada, we've actually been revisiting that issue, and a lot of the courts have been looking at that issue. And last year, our Nevada Supreme Court put out a cardinal case about how bail was being done in the state of Nevada, because it's the Nevada Supreme Court, so it would apply to everyone all over the state. It would apply to Northern Nevada, and it would apply to us. And there's some requirements that must be met, as well as our justice courts have gotten away from we had what was called a bail schedule. They've gotten away from using the bail schedule, and there now has to be a fact-specific determination. They're now requiring specific hearings to be held. And the legislature in this session in 2021, they actually passed a law in making sure that the outlying jurisdictions are going to also have to comply with that and require that people be seen by a magistrate in a certain number of hours, and require that those determinations are made on a fact-specific basis. So the state of Nevada has I mean, there's so much work to be done in the area, but the state of Nevada has begun to start doing those things. I know in Clark County, I can't speak to what's happening in northern Nevada because I haven't been there in a while, but in Clark County, there's definitely been a lot of things put in place to ensure that a lot of things are being treated differently and that they're making the fact-specific determinations on bail.
Thank you. Now, I'd also like to talk about the plea bargaining system as well. So critics argue that the plea bargaining system is more often than not used to save money and time. And Judge Rakoff, you argue a very similar statement in your book. And so can you talk about some of the problematic aspects of the current plea bargaining system?
So if you look at the Constitution of the United States, you can see that the model that the founding fathers had in mind was that people accused of crime would go to trial, they would be presumed innocent, they would not be convicted until the government had shown they were guilty beyond a reasonable doubt, they had the right to silence, and so forth. That's not the world of today. 97% of all felony cases in the United States are plea bargained. And this is a fairly recent development. It began around the 1970s or so. Up to then, while there was still a majority of plea bargains, it was like 60%, 70%, and a meaningful number of cases did go to trial. So why did it change? It changed because in reaction to rising crime rates in the last quarter of the 20th century, Congress and the state legislatures imposed very, very harsh penalties if you were convicted of a crime. These were so-called mandatory minimums, 10, 20, 40 years in the federal system. It was career offenders. In California, 3 strikes and you're out. You go to jail for life. In the federal system and in many state systems, it was sentencing guidelines that, while not mandatory, were very harsh. And the result was that if you were a prudent defense counsel, you could not afford to go to trial. You had to tell your client, you know, I think you've got a shot, but if we go to trial and you lose, the judge is not going to have a choice. He's going to have to give you 20 years or 30 years. And we can get a plea bargain for 5 years, let's take it. And that's what led to this huge increase in plea bargaining. It has a number of unfortunate side effects. One is the system never really gets tested because it's only at trials that the system really gets exposed to public view. Plea bargains are done in private, in effect, in the prosecutor's office. There's no record of what's going on. Second, somewhere between 5 and 20% of those people who plead guilty are innocent. The statistics are the Innocence Project, which has exonerated people mostly of murder and rape through DNA testing and proved that they were absolutely innocent. 10% of those people pled guilty to crimes they had absolutely nothing to do with. There's something called the National Registry of Exonerations, which keeps a record of all exonerations, not just by the Innocence Project, but across the board since 1989. And there, it's actually up to 20% plead guilty. Now, you can't elaborate that automatically to the entire system because the exoneration cases are often cases that someone had doubts about, and that's why they pursued it even after the conviction. But even if we assume it's as low as 5%, there are 2 million people in prison right now. That's 100,000 people in prison right now who are actually innocent.
And I mean, I don't have a lot of follow-up on that because he has all the statistics and all of those things to figure that out, so I don't have anything else to add in regards to that.
And so let's also discuss the potential solutions there. Judge Rakoff, in your book, you said in the UK, there's a different practice. And can you talk about that as well, about the barristers?
Yes, although I think the best solution is to do away with these very harsh laws that have really created the problem. But in my book, since I think politically that may be difficult to achieve, I suggest some other partial solutions. And one would be to have every prosecutor spend at least 6 months out of every 3 years as a criminal defense lawyer for indigent people in another, it would have to be in a different county, different state, to avoid conflicts. But that would give them the perspective that Judge Jones and I thought was so valuable of seeing both sides. And that's not just my idea. That's really what goes on in England. Barristers will be defense lawyers in one case, prosecutors in the next. Now, there are a lot of differences because in England, all the investigation at the lawyer's end is done by what are called solicitors, whereas in most United States, the investigation is overseen at least at the later stages by the prosecutor. So it's not quite the same situation. Nevertheless, I think it would give a much greater balance because the prosecutor really holds all the cards under a plea bargaining system. And often, the prosecutors, in my experience, are very well-intentioned, but they haven't seen both sides, and therefore they tend to give more credence to the police, the agents, and so forth, because they've never had to really look hard at a case in a way that a criminal defense lawyer might.
And I mean, I absolutely agree that I think having had the experience of doing both is absolutely invaluable. And I think when I went about it, I was actually a defense attorney first. So I think when I became a prosecutor, it actually was very, very beneficial to me to have actually seen the defense side of it before I became a prosecutor, who was the person who carried that burden of beyond a reasonable doubt and who was the person making charging decisions. And when I was out in Nye County, you actually had to charge your own cases. So you actually had to read them through, and you actually had to be the person who was charging your own cases. And I think having had that defense attorney experience was definitely invaluable for that. And I think it did make for me to have a different outlook than a lot of other people where this is all that they know.
Thank you. I also want to spend the next few minutes talking about the racial disparity in the criminal justice system. So nearly 40% of African American males are U.S. prisoners, and if current rates hold, 1/3 of all Black men will be imprisoned at some point in their lifetime. Now, the rise in incarceration began in 1973, and it can be attributed to major errors of policy making, all of which have had devastating impact on people of color, especially African Americans. I'd like to hear from both of you about what you've seen in the courtroom as judges when it comes to racial disparity in our criminal justice system and the kinds of policies and the practices that may drive that disparity as well.
Well, I mean, I think there's a lot of things that could be driving that disparity, but I think it's something that everyone can see, the amount of African Americans especially, but the amount of minorities that you see on a regular basis coming through the court system. I mean, I think it's definitely something that everybody should be taking notice of, and I think it's definitely something that should be investigated as far as along the lines of what can we do different? Like, what should we be doing different? What should be done in the underprivileged neighborhoods? What should be done? Because I think that it's definitely something to look at as far as, is it the same things that are happening in one zip code as things that are happening in a different zip code? I think that's definitely something that is worth everybody taking a moment and people figuring out, like, what is it that is driving this? Because I think there are a lot of forces that could be behind it, but I think without actually looking into the different disparities and where it is that they are occurring, it's difficult to figure out the source of that problem. But I definitely think it's something that should become a focus that people should definitely pay attention to and try to figure out how is this occurring and where is it occurring.
So let me start with the statistics, but then turn more personal. The mass incarceration that I refer to is that since the year 2000, about 2 million people have been locked up every year in the United States. That is by far the greatest number of any country. Russia, China, they're not even close. The United States is 5% of the world's population. We are 25% of the world's incarcerated persons. And of those, 40% are not just black Americans, they are black American males between the age of 18 and 34. And they are being ripped from their communities, they are being ripped from their families, they are being put in jail where they'll become better criminals at a time of tremendous personal development to them. And a main reason why I wrote the book that was referred to earlier is I just got so sick, so heartbroken out of seeing day in and day out in my court people who had grown up in broken families, were filled with poverty, who had no guidance, who joined gangs when they were 10, 12 years old, and who now were being written off, in effect, as unsalvageable. The statistics, once again, are that most people who commit crimes before the age of 30 stop committing crimes by the time they're 35. It's a maturing process that goes on. But in the meantime, what are they doing with their lives? They're doing jail time.
I mentioned before about the policies that have contributed to the current state of incarceration, and I'd like to spend just a few minutes talking about that too. If anyone wants to chime in about the war on drugs, perhaps, that have contributed to what we are witnessing now in our criminal justice system.
So I'm old enough to remember how crime rates were rising dramatically beginning in the late 1960s, and that increased steadily until about 1995. And it became, naturally enough, a political issue. And that's when these laws were passed that led to mass incarceration, typically by large bipartisan majorities. And mandatory minimums, career offenders, sentencing guidelines, they were extremely popular. Beginning in 1996, crime rates began to come down. And with the exception of last year when we had the pandemic uptick, crime rates have steadily gone down since 1996, virtually every year. But we are still locking up 2 million plus people, and that's because it's still politically popular. No one has the nerve to repeal these laws. Now, I should give a slight qualification for that. Congress in 2018 passed something called the First Step Act, where they took a very modest first step in reducing some of the mandatory minimums. And it had an almost immediate effect in reducing federal incarceration, not a huge amount, but a material amount. But there's been no second act, no third act. And unfortunately, the intense pressures that we all feel from the pandemic has led to an increase in crime in the past year. And I think that, again, will make it very politically difficult to repeal these, in my view, very bad laws.
Well, I think it is very important because Nevada does something that's similar. It's not a mandatory minimum, but Nevada did get to a minimum and a maximum. And then there's a 40% rule, and it ends up being a whole lot of math that you have to do. But there is a minimum. Whenever any of our judges are sentencing somebody to a prison term, there is a minimum sentence when there's a maximum sentence, and that's something that you have to impose, because prior to that, it was just, you're doing 6 years. It was simply, this is the time and this is what you're gonna do. Nevada has also taken some strides with the categories of different felonies, and it gets super, super complicated, but basically what Nevada did back in 2007 or 2009 is they passed a law where you could get additional credit, good time credits off of your sentence for lower level felony offenses, which is what we call C, D, and E felonies. But the A and B felonies, which A felonies are murder, sex assault, those things, those still were not included. They also changed some of the category B felonies in this last legislative session in 2021 to make it so you could get that additional credit, but there still is a minimum sentence as well as there's a maximum sentence that has to be imposed whenever anyone is sentenced to incarceration in the state system.
Thank you. Judge Rakoff, in your book, you had proposed several solutions, one of which you mentioned before, but eliminating mandatory minimums, eliminating sentencing guidelines, and reducing the severity of sentencing regimes in general. Can you talk about that as well?
Yeah, so I always thought that one of the glories of being a judge was that when it came to sentencing, you would have someone there, a judge, who would hear both sides, who could take account of both the bad crimes that are often committed and the victims who suffer from those crimes, and we should never forget the victims, but also determine what this human being who stands there in the dock, what really led him or her to commit those crimes, and what can be done to make that person a better citizen. And that was the role of judges from the beginning of our Constitution right up until the 1970s when these laws were passed. Now, I see again and again a young man in front of me, typically a person of color, who I feel would best be served by various programs that are available in the federal system. We're very lucky we have more money, and we can offer all sorts of programs to people who have drug dependencies, who have mental health problems, who have anger management problems, and so forth. And I would like to see the person sent there, but I don't have a choice. The law says I got to give them 5 years, or 10 years, or 20 years. And that's the law. And that's not doing anyone any good.
Thank you.
And coming from the state system, it's really interesting because a lot of things that Judge Rakoff talked about is the mandatory maximum minimums. And like I previously said, we don't have that, which would automatically lead people to think that we have a lot more discretion than he would have as being a federal judge, because we don't have the mandatory minimums and maximums. But like he also mentioned, he has a lot more programming and a lot more things at his disposal than I do, because all of this stuff comes down to funding. And the things that are available is going to be what your legislature and what the government is going to fund, because a lot of this stuff is state-run, a lot of this stuff, it's very few facilities that are privately funded. So a lot of it comes down to what is available. And I mean, a lot of times you're faced with the decision of somebody who does have a drug problem, but is this worth them waiting 6 months in custody for a bed in rehab? Because someone who doesn't have health insurance could sit in custody for 6 months waiting for a bed at a rehab facility, because that's just how long it takes for them to get that. So a lot of times, a lot of that stuff is put on the judge to make those determinations. And another difference from the state system and Judge Rakoff and the federal system is I have a lot less information about these people because we have a lot higher caseloads. Our caseloads are very high. And so because of that, the attorneys' caseloads are very high because the attorneys are appearing and making appearance on these cases. So they have even less time to give me all of the information that they would like to, because then they're faced with the choice of, does my client remain out of custody where they could be faced with being this temptation of using or getting involved with the wrong crowd and continuing to get in trouble while I continue to work on this? Are we going forward? Can I get this information? Is my client homeless? Do I have the ability? I mean, they're faced with a lot of challenges as well. So they put a lot of it on the judge to make these decisions, but we're also put into this situation of what is it that's available for us. And it's very difficult because I can't comment on any particular decisions I've made because ethically I can't comment on my own cases and cases that were in front of me. But it is a very, very interesting thing to do every single day to make these decisions. And one thing I did learn when I was no longer a lawyer is there's also a lot of things that become available that I don't know about. Because as judges, we're not invited to the seminars where they talk about all this new treatment. And we're not invited to the community events where they unveil these things. So there's a lot of things that I have to rely on the lawyers to tell me because I don't know about certain treatment programs or things like that that are available without the lawyers telling me. So a lot of it also comes down to, do you have a lawyer who has actually been able to do that research and been able to relay that information to the person who is making these decisions on behalf of the defendants?
Going to the issue of funding just one more moment, because I do think that is a critical part. It's a very expensive thing to lock up a person. It averages in the United States about $60,000 a year per person. So with 2 million people in prison, that's $120 million bucks. That's a lot of money. And there are other expenses beyond that as well. But needless to say, there's no lobby in the state or federal legislatures for people who have committed crimes. And so no one is arguing to the state legislature, oh, it would be much wiser, even economically, to spend some of that money on a mental health program or a drug prevention program or whatever. There are a few very wonderful pro bono organizations that do that, but there's not a massive push for that. And so you don't get reelected as a legislator by saying, I brought a mental health program to the criminal justice system. That's not going to get you many votes.
You know, I'm interested to hear what role politics play in your everyday life, if you are able to comment on it.
Well, I think Judge Jones is going to be in a much better position because federal judges are appointed rather than elected. Most state judges are elected. Federal judges are appointed for life, quote, according to the Constitution, on good behavior, and they haven't caught me yet. So.
And it is true because it's different because I am an elected judge. And in 2017, I was appointed by the governor. And the law says that once you're appointed, you must run in the very next election. So I got appointed in April of 2017. I had to file for office in January of 2018. And I had to run for what's called a retention election in 2018. I was very lucky that no one filed against me, so I ran unopposed in that election. And then you have to run when the term is up. So then I had to run again in 2020 because all of our district court judges' terms were up in 2020. So now I have been elected to a 6-year term. But being an elected judge absolutely gives the political, it just gives that political view to the job that you don't have if you're appointed. Because it's something that, it's real. You have to, the citizens elect you, these are the people that elect you, and that's just the way it works. And I know in different jurisdictions, elections work different. So a lot of it also comes down to you have to figure out how elections work in your jurisdiction. And we had a lot of interesting things happen in 2020 in elections that had never happened before. Prior to 2020, our bench of 52 judges was 26 women and 26 men. After the 2020 election, which now we increased, we have 58 judges, we have 40 women and 18 men. The women ran the ballot in 2020. And so nobody knew what was going to happen. And during the middle of a pandemic where everybody's campaigning on Zoom, literally you're attending events every single night on Zoom. It was a very, very interesting campaign in 2020 to say the least, but we made a lot of changes. And now we're coming to the 2022 election and people don't know what to expect. Are we going to be able to come back out in events? Are we still going to be on Zoom? People don't know what to expect. So it definitely changes the atmosphere of, everything that's going on and what it is, makes you think about, how you got here. Mm-hmm. And as much as I mean, we all, I think, me, and I think I can speak for my colleagues when I say we strive to do the best job that we can without considering that, but I don't think anyone can ever say it's something that they've never considered, because you can't consider it during the election in 2020 and then forget about it until 2026. You just can't do that.
Going back to the issue of mass incarceration, and I know there are a lot of moving parts. This may be a loaded question, but what do you think is the first step in reducing the number of people who are in our prison system?
So, at the risk of repeating myself, I think the most obvious step is to do away with mandatory minimums, career offender statutes, and sentencing guidelines. I was very interested to hear that Nevada has a different kind of system, but most states have mandatory minimums. Most states do follow this problem, and that would be one solution. I also think a point that Judge Jones made reference to earlier, which is how judges in the state system have so little time, because their load is so heavy, to look into the particulars of any given case. The average allocution, what's an allocution? That's where the guy gets up and pleads guilty, and in a plea bargain system, that's 97% of the accused. The average allocution in the United States lasts 13 minutes. Of that 13 minutes, 10 are telling the defendant all the rights that he or she is giving up if they plead guilty. So only 3 minutes is really a discussion about the person, the case, anything that might be substantively important. So I do think, this is not in my book, but it seems to be obvious, that one important step would also be to have more judges to deal with this huge overload.
And I think there's been a lot of great suggestions thrown out today, and it just becomes very interesting, because I think we always get back to the separation of powers issue, because in Nevada, a lot of things that have been suggested all run through our legislature, and that's the executive branch, and I am the judicial branch. So we always talk about that separation of powers issue, because we can't really lobby the legislature. We can't lobby for the laws. We have to enforce them after they've already been made, because you run into this issue of that's their role. Their role is to make the laws, and then it's our, I'm sorry, they're the legislative branch. And then our role is to enforce the laws after they've already been made. So while I think a lot of people would probably agree with a lot of the suggestions that were put out, it's definitely also to a issue that has to go to your legislature, or however it's done in the individual states. But in the state of Nevada, it's done with your legislature, which I know you guys know, they only meet every 2 years. They meet for 6 months, 120 days. It's not even 6 months. It's 120 days every 2 years. So they finished up in June.
There's a cushy job.
They finished up in June, and they'll be back in session in 2023.
The topic brought up about mandatory minimums. How do you ensure that victims have a say throughout that process?
Well, and I'm glad you raised victims, because in any informed sentencing, they're a very important part. So where you don't have mandatory minimums, this would typically be in so-called white-collar nonviolent crimes. The federal system allows the victims to come into court at the time of sentence and have, explain exactly what it was that was done to them, which is often very moving and very important to any judge in drawing a balance. The irony of mandatory minimums is that the victims are an irrelevancy. For example, in drug cases, what determines whether it's a mandatory minimum of 5 years, 10 years, 20 years, or in some cases even more. It's the weight of the drugs that were sold. And this is typically in the federal system a conspiracy. So you will have maybe, I have a case going on right now with 12 defendants. There's a guy at the top, and there's one or two people at the bottom. They are all facing a mandatory minimum of 20 years because the conspiracy as a whole distributed an amount of drugs that brings it within the mandatory minimum guidelines. So it has nothing to do with the victims. It has nothing to do with the perpetrators. It has to do with something that is largely often an accident, which is the weight of the drugs that were actually distributed.
Now, Rakoff is, as I mentioned, a commissioner on the National Commission on Forensic Science and served as co-chair of the National Academy of Sciences Committee on Eyewitness Identification. And in your book, Judge Rakoff, you talk a lot about the issues surrounding eyewitness testimony and false identification, like human perception and memory. So can you also explain that part of the criminal justice system as well?
So this is, to my mind, one of the more troubling areas because it's not totally obvious what the solution is. The Innocence Project, as I mentioned, has exonerated hundreds of people using DNA. And in 70% of those cases where the person was wrongly convicted, there was, in fact, the single most important item was eyewitness identification. You're the one who did it. I'll never forget that face. That kind of very powerful evidence, typically given by bystanders who had no motive to lie. So what accounts for the inaccuracy of so many eyewitness identifications? Well, some of the reasons are obvious: poor lighting, bad eyesight, and so forth. If any of you have seen the great movie My Cousin Vinny, it's well illustrated in that situation. But that's something that judges and juries recognize from common human experience, and they can deal with that. What the National Academy of Science found out, looking at scientific studies that have been done over the last 20 years or so, is that there are some more subtle issues that are not obvious and are not easy to deal with. I'll give just two examples, but there are many such factors. One is the racial effect. It is well established that people of one race are much better at remembering the fine facial features of someone of their own race than of someone of another race. There's a debate over why this is true, whether it has to do with upbringing or whatever, but it's well established that it's true. And it goes across all the races. So a white person is not nearly as good at remembering the facial features of a black suspect as of a white suspect. A Chinese person is not nearly as good at remembering the facial features of an Indian person than of a Chinese person, and so forth. And that leads to a lot of mistaken identifications. A second, even more subtle issue is what's called the merger effect. So you are a bystander, you witness a crime, and if someone could take a photograph of what you actually remember in your brain at that moment, they would see that you only have a vague perception and remembrance of the exact features of that person's face, who you might have seen only for a very short period of time, and you might have been more focused on the gun he was carrying or whatever. But you are then given either taken to either a lineup or a photo array, and these days it's more often photo array because they can be generated by computer very easily, and you're shown 7 photos, and if it's done right, and many police departments do it exactly right, the police person conducting this does not say, oh, you should pick one or you should pick another. They handle it very neutrally, and the eyewitness studies carefully these photos, and he's not sure that any of the 7 are really the guy, but the one that looks most like what he remembers is a guy who in my hypothetical, had a scar above his right eyebrow. Now, fast forward to 2 months later when he's talking to the prosecutor, or if the case does go to trial, a year later when the case goes to trial. Those two memories will have merged. This is not something conscious. This is just the human brain operating in the way it does, and he will be able to honestly take the stand or tell the prosecutor, I will never forget that guy because I remember the scar above his right eyebrow. In fact, he did not see a scar above the right eyebrow. He saw it in the photo, and the photo was the one he thought was most like the guy. But now the two memories have merged, and he thinks he saw it at the time of the crime. Very difficult thing to deal with, but it leads to many, many mistaken eyewitness identifications, which are, by all reports, one of the major factors in innocent people being convicted. What can be done about it? Well, you can't change human nature. You can't change the brain. In New Jersey, they have a jury instruction that alerts jurors to this problem. The preliminary studies are not very suggestive that that really is making a difference. My own feeling is that because so much of the system is now in the hands of the prosecutors and everything is plea bargain, it would be very helpful for every prosecutor to have maybe a half-day training session at the beginning of becoming a prosecutor on the frailties of eyewitness identification, so that the prosecutor would look at other forms of evidence and not place such a huge weight on the guy who says, it's him and I'll never forget it.
Mm. Now, is that a pretty recent issue?
Yes, the National Academy of Science came out with its report in 2014, and I was privileged to be co-chair of that committee, but the real brilliant mind was my the other co-chair, Tom Albright, a very famous and terrific scientist in the perceptual field, and he's gone around the country since then trying to interest people in doing more and training people about these frailties, but it, a long way to go.
Definitely. Judge Jones, have you heard about this issue, and have you seen anything in your courtroom that you're able to talk about when it comes to eyewitness testimony and false identifications?
I have heard about this issue, and I've heard about it basically like on the news and through the Innocence Project. I don't have any particular instances that I've personally had in my courtroom, but I have heard about this issue and that, it's becoming a bigger issue.
Mm-hmm. Thank you. Before we get to any questions here in the courtroom, Judge Rakoff, are there any other topics mentioned in your book that you wanted to speak briefly on?
Yeah, just one. Because the last chapter of my book talks about access to justice by everyday folks, not in the criminal justice system, but in civil disputes. And this is another major problem in my view. As recently as 30 years ago, most people who were parties to either housing court disputes or family court disputes, which are the two most common disputes that everyday folks get involved in terms of the court system, were represented by a lawyer. Now, nationwide, only 1/3 of those people are represented by lawyers, and in some states it's as little as 10%. And that's a huge failing on the part of the legal profession. For various economic reasons, lawyers have become more specialized, more expensive. You see it happening in medicine as well, but there you have insurance. And so you can pay that higher rate that the specialist has. No such provision in the legal system. And the result is that the great majority of everyday folks who get hauled into court in like a landlord-tenant dispute or a divorce action or a custody battle don't have a lawyer. And it makes a huge difference. The statistics are those who have lawyers win at least 50% of the times. Those who don't have lawyers win only 5% of the time.
Thank you. We do have a mic to the left hand of the stage. If anyone has any questions, we can take them now. Don't be shy. You can just use the mic over here. Any questions? Yes. Do you mind just using this mic for the live stream? Thank you so much. We can have someone bring it to you as well.
Is it on? Is that working? Yes. Okay, so my question is, when you have the discretion with a victim impact statement, how much does that affect your decision? And then another part of that is, what if the victim or the family of the victim forgives the perpetrator?
I'm sorry, what was the last part?
If the victim isn't, not someone who's been murdered, obviously, or the family of, say, a murdered victim, if they forgive the perpetrator, how much does that impact your sentencing when you have that discretion?
Yeah, it's an excellent question. I think the two most important things that should go into sentencing is the character of the defendant and the harm imposed on victims. And to hear personally from the victims is often heart-wrenching. But the impact, which is the question, is that it often does lead to a higher sentence than would otherwise be the case. I think that's human nature. I'm not sure it rationally can be defended, but I think that is the reality of it. I have had victims in my court who have forgiven the perpetrator. I'm less forgiving myself. I think it is good for them emotionally. I think it helps bring about closure for the victim. But I'm not sure that should be playing a role. If someone intentionally commits harm that has often a lifelong impact on the victim, then I think some punishment is in order. I think it would be not appropriate to simply look at the maybe very real excuses as to why that defendant committed that crime. That's important too, but I don't think that's the whole story. But what your question illustrates is why I hate mandatory minimums and career offender statutes and the like, because this is a subtle balance that needs to be brought about after being carefully informed of all the factors that a judge should weigh, rather than a law that is passed by legislators who have no idea about any individual case, but just say, oh, it's a terrible crime, let's lock them up.
And I think I would have to agree in a general sense that you should absolutely be taking into account what the victims are saying. And I head up our homicide program, so I hear from victims, and it's not the actual victim, it's their family members. They come in a lot on the sentencings on the homicide cases because, that is most of the time when you do see the victims. I don't see a lot of victims on the stolen cars and things like that, but in the homicide cases, I see the victims, their family members a lot. And I think it's definitely something that absolutely goes into making the determination of what's going to happen. I can't put a number on, I'm going to give it this much value, I'm going to give it this much value, because it's also very interesting to see how different victims are at different places in their healing process. Because in a 2-week time, I could see people who they're going to hate this person forever. But I've actually seen people who have forgiven the perpetrator. But while they have forgiven the defendant, that doesn't take away that there was a crime committed. So from a legal standpoint, you can't wipe the slate clean because this person has forgiven them. Either they've been convicted by a jury of their peers, or they've already pled guilty to committing this crime. And so from a legal standpoint, the crime still stands and they still have to be sentenced on it. Just because this person has forgiven them, that's a factor, but it can't wipe the slate clean from a legal standpoint. We just can't.
Thank you. We also received a question online. This question is from Debbie, and we'll have both of you answer this as well. She said, do you feel the entire justice system needs to be overhauled? Maybe after this conversation.
I feel like there's so much room for improvement in everything that's happening, but I do think there's also good things about the justice system. I do think that there's good things about it, and we're not in a position where I think everything needs to be thrown away and we need to start over from scratch, because I think a lot of it too is being a part of that system. I think a lot of people, like Judge Rakoff talked about a little bit, the people who don't have a lawyer, I think one of the disadvantages that they are at is they don't know the law. And as a judge, I still have to hold them to that same standard, because if you represent yourself, and I always say this, any man who represents himself has a fool for a client. Because you're standing up next to a lawyer who this is what they do, this is their craft. You're not going to go into the doctor's office and tell them what's wrong with you or take them on about your medical care, because this is their craft, this is what they do, and you have to be held to that same standard. And I think the biggest mistake comes, you don't know the law, because these people are legally trained. And so I think a lot of people who are in the system and they've had bad experiences for one reason or another, some of those bad experiences come from not being familiar with the law. Like, I know from a moral standpoint, we would like to make the crime go away if the victim has forgiven him. But from a legal standpoint, that's not how it works. So I don't think it's fair for someone to say, well, they sentenced that guy even though the victim had forgiven him and the victim had healed from what had happened to them, because legally you still have to. So I think there's a lot of things about the system that are very complicated, but there are good things and there's also bad things, and there's always room for improvement. But I think we also too have to be strategic about not casting the widest net possible and turning the whole thing upside down, because I think a lot of times that's where failure comes in, because we took on a lot more than we're actually capable of doing. So I think it's very important to look at the little intricacies of the system and be able to deal with those little things one at a time, in the hopes of getting to the point where we have built the system. Understanding that I don't think it's ever going to be perfect for every single citizen of the United States, but building on the little pieces to get to the big piece instead of turning it upside down and then we don't have anything that's functioning.
So I agree that it doesn't need a total overhaul. I think there are nevertheless very, very serious problems in our legal system. My hope is that as people become more aware of them, they will put more pressure on our elected representatives to change it and to fix it. One of my colleagues, a very excellent judge named John Martin, resigned about 10 years ago because he, perceiving many of the problems we've talked about tonight, just felt it was never going to change, and he didn't feel he was doing justice in many specific instances because of all the problems we've discussed. I don't agree with that. I'm more optimistic. I think that all these problems are solvable. I took the liberty in my book of suggesting some of the solutions. But I would also hearken back to that greatest of all documents, the U.S. Constitution. It's the U.S. Constitution that says, let's not have excessive bail. It's the U.S. Constitution that says everyone has a right to a jury trial before their peers. we've departed very far from what the Constitution had in mind, but there's really nothing but our lack of will that prevents us from going back to what the Constitution recommends.
Thank you. Are there any other questions? Yep.
Hi, my question is for Judge Rakoff, is it?
Is the microphone on?
I'm sorry.
Should be on.
Can you hear me now?
Yeah.
Yes, that's
Okay,
better.
I'm sorry. Probably should take my mask down.
No.
Your Honor, the United States sentencing guidelines provides a number of factors that are taken into consideration in calculating an appropriate sentence within the scope of the guidelines. Is that correct?
Yes.
Okay, and depending upon the circumstances of the case, there are also situations where an upward or downward departure from the guidelines is appropriate. Is that correct? Could you?
Yeah. You basically have it right. Do you want me to elaborate a little bit on it?
Just a little, if you would, please.
Yeah. But I'm a judge. I only talk in lengthy paragraphs. But so the sentencing guidelines were originally mandatory, and you couldn't escape them. That was true for the first 15 years. Now you can escape them, but they still play a major role, because the first thing any federal judge needs to do at the very beginning of sentencing is calculate what the sentencing guideline range is. Yes. He doesn't have to follow it, but it's certainly in his mind. If the sentencing guideline range is 5 to 6 years, he's not going to likely give 1 to 2 years. So the trouble with the sentencing guidelines is they're fundamentally flawed, because they think that all the factors that could go into an informed sentencing can be reduced to arithmetic. And the result is they come up with calculations that have no basis other than in the minds of the sentencing commissioners. Moreover, because they are attuned to things that can be measured, they place inordinate weight on the weight of the drugs in drug cases, or the amount of money in white-collar cases, on things that are not irrelevant, but certainly are not the whole picture. A guy goes into a bank, and he's a bank robber, and he says, "Stick him up and hand me all your money." And the teller that day has $300. Next day, another guy goes into the bank and says, "Stick him up," and the teller that day has $3,000. Under the guidelines, the second person is going to get a much higher sentence than the first person, even though their motivations, their situation was really identical. Mm-hmm. So the guidelines are, I think the correct judicial word is irrational.
Thank you, Your Honor.
Any other questions? Yes. Do you mind just using this mic? Thank you. I know.
So my question is, do you think maybe that people are in favor of mandatory sentences and things of that nature? Because it seems like the justice system now is way more concerned about the rights of the criminal as opposed to the people who've been harmed?
I am sure that is part of the philosophy. I think it's completely untrue. I think it's totally untrue. How many more million people do you want us to lock up before you're convinced that we have some concern for the victims and no concern, and have a punitive attitude towards the perpetrators? 3 million, 4 million. It's a complete myth what you're suggesting, but it is a commonly held myth and influences the way people like yourselves and others think about it. The truth of the matter is that because the penalties are so high, all those rights that you're referring to don't get exercised. The person just goes into the back room with the prosecutor and cuts a deal. And the deal is largely in the hands of the prosecutor. And by the way, there are soft prosecutors and harsh prosecutors. So two identical people, one will wind up with a 5-year term and the other with a 10-year term, just on the whim of which prosecutor happened to be in charge that day. I do not see guilty people getting off, which is the real test of what you're referring to. It happens once in a blue moon. It happens very, very regularly. I do see proven that many innocent people are being convicted, and that's not a good thing.
Correct, and I would like to remove the whole drug, from that situation, because I understand that, too many drugs are a victimless crime, and I think there's a lot of work that can be done there. But for violent crimes, and particularly, I don't know how long, I know you're from New York, I don't know how long you've been in Las Vegas, but just recently, a state trooper was killed by a 9-time convicted felon. Why was he on the street? What judge decided it's a good idea to put this man, who's had 9 chances, back on the street so he could run over a state trooper who now has a wife and 2 children who have no father in the home? Because this guy was still on the street. He stole a car, ran over a state trooper, and what I'm hearing from you is, well, maybe his daddy didn't love him, so we should just let him back out.
No, that's not what you're hearing from me. But first of all, I don't know anything about that case, so I can't comment on that case, but I get your general point. So let me talk about my own personal experience. So many years ago, my brother was murdered in cold blood by a guy who, they were fighting about money, and the guy picked up a lamp, actually, and bludgeoned him to death. And if you had asked me then what should be done to the defendant, to the killer, I would have said, fry him. He's forfeited his right to live. He's killed the brother that was so close to me, who I admired hugely. And I understand those feelings completely. But I also understand that many people who were on death row because juries had concluded that they had done some awful crime turned out to be innocent, didn't even commit the crime. It wasn't that they committed some other crime and got, this was just a more exaggerated version. They didn't commit the crime at all. And we're talking hundreds of people, maybe thousands. And so it's a balance. And you need to, that's what judges try to do, is balance. And what I'm suggesting is that the system does not allow judges to balance things the way that it once did, and that I think ideally it should.
Agreed. I think it's a very tough job, but I think that's the reason that repeat offender laws are so popular, because as just a common working person who is tired of coming out and your car's broken into or your garage is broken into, they just want to see these people put away. That's my opinion.
I've had my car broken into too, and believe me, if you had asked me right then, I would have said, send the guy away for 10 years. But that's, it's a question. Is it not helpful to you to know that crime rates, with the exception of last year, have steadily gone down in the United States for the last 20 years, and that the main reason for that, according to many studies, has been an increase in the economic circumstances of poor people. Poor people are, frankly, the most likely to commit crimes, and because of economic growth, the crime rates went down. Now, there were other factors as well. Another important factor was that the police changed their methods of investigation. So in New York City, the police, back when crime rates were going up, used to patrol through cars. And then someone got the bright idea that they'd be much more effective if they patrolled on the street, walking to and fro, being a visible presence rather than someone behind a windshield. And that was a major factor in the decrease in crime in New York. There are a lot of good things that have happened too, but not because of the harsh laws imposed by Congress and the state legislatures.
Thank
Okay,
you.
thank you.
Are there any other questions? Okay. We have run out of time. I just want to say thank you to all of you who shared comments tonight and who came to listen to tonight's discussion, and a special thanks to our panelists, Judge Tierra Jones and Senior U.S. District Judge Jed Rakoff, for being here tonight. A round of applause for them as well.
Something that simply mystifies.
Oh, thank you.